everybody. Thanks for having me here today. One of the things that I love about teaching a smaller class is it's a little more intimate and we can answer more questions, and so I'm happy to have a good crew today, just small enough that we all still can connect with questions. So for those of you who know me, and I'm noticing probably half of you I've met before or have worked with you, so thanks for coming today. I know that it's a time commitment. I know many of you are either serving on your board or have previously served on your board or are thinking about serving on your board, or maybe you're a homeowner. One thing that I'd like to do before we get started is to just ask for a show of hands. How many of you are board members who are serving right now on your board? Okay, so more than half, great. And how many of you are former board members who are currently not serving? Got a couple, good, okay. And how many of you are homeowners who are not board members? Few, okay, watch out, you two. You're probably gonna get on the board soon. Just in terms of some experience and my background, I'm a native of Milwaukee, Wisconsin, and I moved to Arizona in 1995, and I started practicing law in this area of representing associations. So I have been doing this now for 22 years, and it has been a wonderful practice area for me. I love the problems that associations have. I love working with the boards. I think I really have a wealth of information to provide based upon the length of my career in working with associations. If anybody's having difficulty hearing me, just give me a little 2 fingers up and I'll be sure to make sure I increase my volume, because it is kind of, there's an air conditioning going. I've always got a trickster in the back row, I know that. So in addition to being a lawyer for associations since 1995, I've also served on my board in 2 different instances, I'm currently the treasurer of my board, and I've served as a director at large. I've also been on the architectural committee. I also had a stint as a disgruntled disgruntled owner. So there was a time period where I was on my board and then I started having children, and I just decided that maybe I needed to cut back a little on some of my board responsibilities. And then I got back on my board, but in that interim period when things were not going very smoothly at our association, I became a little disgruntled about how things were being handled, and in a nice way tried to work change from the outside, and ultimately decided the only way to make change is to get on the board. So just keep that in mind. I think the last class that I taught, I believe, was on the Eisenhower Method, which was a new class that we had, which I thought was a really good class subject. And that was just explaining how boards can get things done, because the biggest complaint that we hear in the industry is our board never gets anything done. You know, we spend a lot of time talking about, the red flashing light of, dogs barking, parking problems, but we never talk about like strategic planning or any of the big meaty issues that our association really needs to be talking about. Today, we're going to be talking about everything about pets. And this actually, it's amazing that pets in associations cover so many different topics. When we were thinking about teaching a class on this, we actually had to limit what we would put in the class, because pets and pet issues, there's so many different issues that come up with that. And so I think today's going to be a really fun class. We're going to talk about chickens, we're going to talk about pot-bellied pigs, we're going to talk about dangerous breeds of dogs, liability, how to handle owners that don't comply with the behavior of their pets. So it's going to be a great class. Just as usual, Chandler is cutting edge. This is the first time I've taught this class, although I'm extremely familiar with the subject. So one thing that I always say about Chandler is that they're always doing things first, and that's really great. That's how we want. I love working with a city that's like that. Okay, let's start out a little bit. I put on the walls our parking lot signs. When we take a little break here in about 25 minutes, we're going to then dig into the food. Or if you're really hungry, feel free to just walk over, and I know you can listen and walk at the same time. I see my son doing it all the time, doing something else while he's doing that. When we take our little break, if you have any questions that you want me to place on the walls of the parking lot, I then will start out, or we'll finish with the questions at the end on the parking lot. I already see one that Bob put up there for me. But it's just an opportunity for you to have a free venue to ask any question that you want, and it's anonymous. So I'm not going to call out, if you don't want to be the one that raises your hand and asks the question. I also offer that if you want to call me anytime tomorrow, if you think of a question after you walk out of here, you can call me for free anytime tomorrow and ask a few questions if you have any. So, okay, let's start out with everything you need to know about pets in a community association. Surprisingly, when we were putting together this class, we did a little research as to how many owners in the United States have pets. And according to a pet owner survey, this is from 2015 and 2016, approximately 65% of owners or households in the association have a pet, and that's 79.7 million. So it's really no surprise to me with that high of a percentage that there's going to be issues that come up with pet owners, behavior of the pets, et cetera, in our day-to-day business of representing associations. What we did is we created a cheat sheet that is designed to basically come up with what are the most common questions that we hear about pets, and then what are the answers to help you best handle pet issues in your community. And I gave everybody with the handout that you received when you came in today, has that new cheat sheet that we just put out there. Okay, let's first start talking about rules and regulations on pets. Before we say anything, I would like to just remind everybody that it's always a great idea when you're changing your rules or you're promulgating, creating rules, thinking about how you're going to get them passed, run the rules by your association's legal counsel just to make sure that there's nothing in the rule that is contradictory to federal law or state law or your documents. A very common problem that we see is that we come in after the problem. Like, let's say that a board passes a rule that is contradictory to what your documents state. So for example, your documents allow pets, and you decide to pass a rule saying that dogs, can only, they have to be less than 40 pounds. That is going to be something that would not be upheld if that's challenged, because the CC&Rs control over the rules, and if the CC&Rs don't have any sort of a pound limitation or any sort of restriction on the number of pets, you can't pass a rule to go around that. So you always want to be really careful. It's something that I say, that we typically will say is called preventative legal. Be preventative in how you handle your affairs as a board. Because what typically happens is a lot of times people will say, oh, don't go to the attorney because it'll cost us money. Well, sometimes that's true, but most of the times it's not true. Like, if you're coming to a class like this would be a great free venue to ask a question about something that your board's thinking about doing. Or our firm also has a free call-in the first Friday of every month between 9 a.m. and 10 a.m. You can call and ask a question then. So there are lots of free venues where you can, ask a question. Or you can, ask your attorney, on the clock, so to speak. Hey, is this rule that we're thinking about doing, is this going to be okay? Because what usually happens is if you don't do preventative legal, it's kind of like preventative medicine, right? If you don't ever go to your doctor for a checkup for 20 years, and then on year 21, you go in for, an emergency room visit, and they find 50 things wrong with you that you could have, handled if you had just had regular care every year. And so it's kind of the same philosophy. So make sure that you get those documents checked to make sure that whatever you're passing or anything that you're putting in your CC&Rs is consistent with state law, federal law, and your other documents. Because what usually happens is the board passes a rule, maybe it's an invalid rule, an owner gets pretty fired up about it, and guess what happens? There's a lawsuit, right? And then now you're looking at, $25,000 in legal fees, or maybe an insurance claim if it's covered by your insurance. That all would have been preventable if you had called one of the free opportunities, or if you had just spent $50 with an attorney asking, hey, what do you think about this? Okay, so most associations have some sort of a pet restriction located in the CC&Rs or rules and regulations. Common restrictions include what are the type of animals that are allowed within an association, a limit on the number of animals allowed per household, or a limitation on the size or weight of the animals allowed. Further, many associations have provisions that require a pet owner to, pick up after their pet, or prohibit a pet from becoming a nuisance within the community. So your association may have, for sure, you have a nuisance provision. I don't think there's ever been a set of CC&Rs that I haven't seen in Arizona that didn't have a general nuisance provision. So if you have a pet that is behaving in a way that's a nuisance to others, that's going to be a real general pet restriction that you would be able to enforce. But then I have some associations that have really specific ones where they limit the number of pets in per lot, or they talk about dangerous breeds, or they talk about weight, how heavy a pet can be. If the CC&Rs and rules for your association do not contain pet provisions, the association may consider amending the CC&Rs or rules and regulations to contain some pet restrictions. A rule or regulation regarding pets, whether it's in the CC&Rs or in the rules, it needs to be reasonable, it has to serve a purpose, it has to be acceptable to your owners. I'm not saying that it has to be acceptable to 100% of your owners, but a great majority of the owners should be in favor of the rule. It needs to be enforceable, right? The pet weight limitations, those are really hard to enforce, right? Do we have a weigh-in every year, and are people putting their pets on a diet? So I can tell you kind of just from experience what works and what doesn't work. And if you're running it through your attorney, they'll say to you, I know you really want to limit the dogs to less than 50 pounds, but let's think about this from a practical purpose. How are we going to do that? How are we going to, is it visual? Is it going to be they have to go and get a certificate every year from their vet saying how much they weigh? Then you've got to keep up with that. The future boards are going to have to do that, which makes it kind of difficult. And then make sure that it's consistent with the other governing documents and Arizona law. Again, the association should have your legal counsel review the proposed changes to ensure that the amendments are legally proper and enforceable. If you adopt new pet restrictions that would affect owners that have pets already in violation, you really need to think about grandfathering those owners, right? So let's give an example. Let's say that your association decides to pass a restriction. Let's go back to some sample ones. A limit on the number of animals per household. So let's say that that's going to need to be, we can kind of talk about these. So the type of animal allowed within the association, that has to be a CC&R amendment. Okay, so if you're going to try to limit the dangerous breeds or the breeds that people think are dangerous, that needs to be in the CC&Rs to be enforceable. A limit on the number of animals allowed per household. Again, I would suggest that you put that in the CC&Rs. And that's one where, let's give the example of having to grandfather people. So let's say that your board decides that typically what happens is there's just too many animals, the board thinks, for the size of the association, and the common areas are turning into a dog park in the afternoon or whatever. And they want to limit it to maybe 1 or 2 household pets per unit. Typically this would be in a condo. And let's say that you have somebody right now that has 4 pets, right? What do we do with them? Well, that's a good strategy discussion with your attorney. What you don't want to do, and I'm just telling you this from experience, is you don't want to say to the person that owns the 4 dogs, you need to get rid of 2, right? Right. But what you may want to do, and I'll come right to your question, is grandfather that owner, as written in the amendment, that anybody who has, in excess of the 2 pets that are now allowable under the documents, they have to register the pets, and then they will be able to keep those pets until they move or until the pets perish or, whatever. So we write that right into the amendment, so there's no pushback, no problems. Anybody who's voting understands, okay, it's only 2 pets going forward, and then all the grandfathered people, there's written documentation to show that they're grandfathered. They take a picture of the dog or the cat or whatever, so that we make sure that it's not replaced improperly. I'm going to go to her, and then I'll come to you, Bob.
Okay, when you talk about the number of pets, do you have to define, like, this bird, say birds, or you have lizards, or we had a pet parade and somebody brought their snake. So, can they have a bird, a dog, a lizard, and a turtle, or something like that? What are pets?
I think it's best to be specific when you're doing an amendment like this, because there's all kinds of odd pets now that are coming into the scene. We're going to talk about pot-bellied pigs. We're going to talk about other types of pets that we weren't talking about 15 years ago. And so I think it's best to specify. Usually what we see in the documents is commonly accepted household pets, which probably it would cover birds, it would cover dogs, cats, but I think it's best in this day and age to cover what's acceptable and what's not, and then leave a back door and say something like, or upon petition by the owner to the board, any other pet that is approved in writing by the board can also reside on the property. Yes. Oh, I'll go to Bob real first, and then I promise I'll come back to you. Okay.
I just didn't know she was.
So Beth, wouldn't it be a good idea, so if you had allow only 2 dogs, you grandfather 4 in, but then have language to say as dogs drop off down to 2 and go back up to 4?
Exactly. So it'll be written, we write it right in the amendment that's passed and recorded. And we specify that as soon as they move or if they no longer reside there, I mean, and it could even be that they just move out for 2 years. Then that would be the trigger. We write it very specifically, and then they can't replace it. Now, I mean, there's strategy here. So you need to talk with your lawyer, and if you say, hey, listen, 60% of our owners have more than 4 dogs, maybe we need to write it in such a way that we grandfather them for as long as they own, or maybe we allow them to replace a pet so that, you know what I mean? We need their vote. So lots of times when we're doing amendments to CC&Rs, what we'll say to the client is, okay, what do you think the pushback is going to be from this on the homeowners? And we're doing a lot of this now on the rental restrictions. Maybe you have 35% of your homes are rentals, and you need 75% of the homes to pass an amendment, limiting rentals. You better write that in a way that's favorable to the current people that are renting, or you're not going to get that passed because you need their vote. So, we strategize. We come up with, I've written all kinds of pet amendments. You may have to allow them the number for as long as they own, and then whoever the next buyer is, it's 2. Yeah, and sometimes that fine tuning occurs after you fail on the first attempt because you get a lot of pushback. That's why I really encourage boards, when you're doing an amendment to the CC&Rs, we have a little cheat sheet that we put out there called the 5-step plan. Step 3 on the plan is go to the homeowners before you ask them to vote on an amendment and ask them, what do you think about this amendment? The good reason that you do that is because you find out all of the negativity or positive thoughts about the amendment then. Much better to find out then than to find out on the ballot vote where you lose. And so that's a really important step when you're doing an amendment, to make sure you ask the homeowners, hey, what do you think? And you won't get a lot of feedback, trust me. People don't participate that much, but the 5 people that take the time to fill out a comment card on it or that come to a board meeting, their comments are probably more indicative of 20 or 30% of the people, what they're saying, the comments that they're saying. So you really do need to listen to those people. So I'm sorry to make you wait. What was your question?
Okay. It was just that I think ours read, for example.
And they give examples.
Green snakes, 3 or 4 things. Sounds like we should be more specific, be more thorough in expected household pets.
I think it's good to be thorough, but like I said, things change. I mean, if somebody had told me 15 years ago that people would be living with pigs inside the home, I wouldn't have believed them. And so I like having, you could list the different types of animals that you allow, and then you could maybe do something that says, or, if you go to the board, you can ask for permission for anything that's not on this list. That would be a good idea. Typically, how you find out about a strange animal type situation is a neighbor sees it.
You see the 3 and 4 dogs, too.
Right, or they see it on the top of their fence or whatever, and they get scared, and then they go to the board and say, and then we follow up with that homeowner, and they say, oh yeah, I do have raccoons. I thought those were okay. Aren't we allowed to have raccoons? So, yes.
Issue of feral cats. I have a neighborhood that had that problem. Somebody was feeding them and made a pretty good mess of that area.
So feral cats can definitely be a large issue. So that's a question. He lived in an association where there were issues with, the feral cat population, and what does an association do in those situations? I've had different associations tackle it in different ways. I mean, cutting off the food source is by far the most important thing to do, because once the cats know that there's not going to be free food every day, they'll go somewhere else where there will be free food. But that's going to be a monitoring of homeowners type of situation. That is something that I think that you could pass a rule on, stating that owners, shouldn't be feeding, feral cats on their property or on the common areas. Yeah, or you could get them under the nuisance guideline. So I would say, pass a rule on that, but then you're going to have to enforce it, meaning you're going to have to see that bowl out there, snap a picture, and then fine that owner for that behavior, which in my experience has been that the owners that are likely to do that, they will do anything to feed those animals, whether it's putting it out at 3 a.m. or whatever, so it's hard to watch that. I have had some associations that have hired a company to come in and trap the cats, and they release them into the, North Scottsdale, I think is where they do it. There's a company by the name of All Animal Transport that does that. You can also call the Humane Society. Sometimes they'll come out, but I think it's such a problem that it's less likely for the Humane Society at this point to do anything on it. Does the city of Chandler have anything on that?
Yes, I actually have some information that I want to share with all of you. The city of Chandler is now offering neighborhood grants for trap, neuter, and return of feral cats, because some of the companies were not sure like where they're taking the cats, and we're kind of looking into the laws about cats and relocating animals, not feeding the animals. But a lot of the behaviors that you notice in cats, and I'm highly allergic to cats, so I'm not like advocating cats or anything, I'm just letting you know. A lot of the behavior, that's the negative behavior, comes about because they haven't been fixed. So what they do is they'll take them, they fix them, you can pay for it through our neighborhood grants, they clip their ears, so they're kind of becoming neighborhood cats, and they do help with like rodent issues and scorpion issues and things like that. And if you do have a group of neighbors that's passionate about cats, you should have them come, contact us so we can put them in touch. We're working with the Animal Defense League of Arizona too on this, because we also want to minimize the overpopulation of cats. So, and we don't want to have them relocate. We want to keep them in the same general area. You kind of move them around a little bit, but you do want to stop feeding so we can trap them, take them, and have them fixed. But I think that's going to be a good solution in the long run, because also those relocation places, they are very expensive.
Oh, yeah, it's like $45 a cat.
Yeah, and so the city, can offer you grants, and they won't populate anymore. Eventually the colonies, die off. So I just want to share that with all of you, and I do have information, I have grant information. So if you do have that lady who likes to feed cats, I have one of those in my neighborhood, let them know about these grants, and think of it as an option, because it doesn't cost you any money, and they can still continue to provide food and water and kind of contain them in an area that's okay, as long as they agree to, pick up the mess, the cat mess. And you'll be surprised how many people are open to that.
Great. It sounds like a really worthwhile program. Just to recap for the video, the city of Chandler has a program where they can they help you trap the cats, and then they take them and get them fixed, and then reintroduce them back into your neighborhood. The association would pay for it, or they could possibly get a grant. Is that right? Okay. I'd be interested in publicizing that on our website, because we have a lot of, this is a common question that we get from associations. What do we do with the cats? And I wasn't aware that some cities were doing that, so.
Yeah, I think we're one of the first cities, and it's a really humane way to treat the animals, and there are positive aspects of having cats in your neighborhood, truly. So we have a lot of information on that.
Great, thank you, wonderful. Yes, Bonnie.
It seems like this might be an appropriate time. We are thinking about reintroducing a dog committee, but instead of just earmarking it dog committee, would it behoove us to call it a pet committee?
By a doc committee meaning document? Or no, did you say, document, DOC?
No, dog
Oh, dog, okay, sorry. Yes, I would, because the nature of the commonly acceptable household pets is changing. So I would just call it a pet committee. I think that's a great idea. And you're gonna learn a ton of good stuff for that committee today. If you want extra handouts, or if you want us to email them to you, let us know for your committee. Yes?
We have a small association, and we kind of do that already, as far as, there is some feeding, but we trap, we neuter, and we keep, 7 feral cats? Something like that. We have a specific number. If more come in or more are there, then they're appropriately moved, but we control it that way, and we want them there.
Good, to help with rodents, et cetera. Okay, great. See, I didn't even know that was occurring, so wonderful. Yes?
Just wondered if you would define for me what household means?
Per household?
Household. What is the definition of household?
So I would say whoever's occupying the unit or the lot.
Because what we get is we have a community where the people are already there. They have 2 animals, are allowed 2. Then a family member moves in with them and also has 2 animals.
If
Now,
they're
the question
living
is,
in the
how do you do
household,
that?
yeah, they can't.
Okay.
So it's 2 pets per household, meaning those 2 were already taken. And if a new household moves in, so to speak, that's not going to be the right definition of household. They just have additional occupants, but the household is 1 unit or 1 lot. So if you have that,
One lot,
yeah.
define it that way.
Yes, that's how I would define it. I'm sure a court would define it the same way. And that's becoming a really more common problem where we have children moving back in with the parents and then they create a whole bunch of new issues within the neighborhood. But yeah, I would say you should get a letter out to that new addition to the household right away to make sure that they know that they're now in violation of the pet restrictions. Okay, let's talk a little bit about liability. So we started out by saying, okay, if you're going to pass restrictions, you want to make sure you run them through your legal counsel. Now we flip gears and we talk about what's the liability of having pets in an association. First, I want to just start out by mentioning I have personally seen cases involving dog bites, aggressive dogs. I would say those are probably the 2 main things on liability for associations on pets. You know, where the association is named as a defendant in a lawsuit because of the behavior of somebody's pet. And I have actually kind of a fun story to tell you because it's always good to include stories on here. Unfortunately, I have lots of stories on animals attacking owners or attacking other animals or children. But I have one in particular that's actually a really good story. So I represented an association in Scottsdale, and this association had a lot of problems to begin with. But they had this one owner that had a dangerous dog, so to speak, and there had been 2 incidents in the association where the dog had been off leash and had first attacked another small dog and then attacked a small child. And then the dog and the association kind of didn't do too much on those first 2 attacks because they didn't know what they should do. On one of them, they weren't aware of it until well after the fact. And then the second one, they did write a letter saying it came to our attention that this occurred and that your dog should be on a leash at all times. Okay, the third attack by the same dog was that it was actually a tenant, so the tenant's dog was in the back patio area of the property, unleashed, and the back patio area had a wood door that would open and close, and the UPS person came in to deliver a package and opened the gate because that's how you get to the front door. And the dog was right there and basically, mauled this person like I've never seen. I couldn't even look at the pictures without feeling like vomiting. It was that bad. So the association was named in a lawsuit. The UPS driver sued the association. They sued the association's management company. They sued Maricopa County. animal control. I mean, they had a laundry list of people that were named on the lawsuit. You know, when you have a situation like this, and ultimately I think the insurance carrier for the association settled, you know, kind of a de minimis amount. You know, it was less than 50 grand and it was all covered by insurance, but how could that have been preventable? You know, let's talk about that a little bit because we're going to talk about what our liability is. Did you have a question before we get started?
Yeah, obviously, words have meanings. So, that before Cynthia's creating a danger, so danger does have a specific meaning, right?
Yes, so let's talk.
Would it be a better word of nuisance than you can have a broad coverage?
Well, this is actually a specific case that we're going to talk about. You know, the case that came up with this particular law was called the Woodmar Townhomes. You know, Martinez versus Woodmar Townhomes, and this wasn't a dog bite case, but what the ruling in the case is extended now to dog bite cases or aggressive animal cases. And basically, what happened is the court in the Martinez versus Woodmar case held that associations have a duty to keep the common areas safe and free from crime. And so the safe element is going to be the dog analogy here. And so I guess when does it trigger that we have to keep it safe, right? So the first thing that we want to look at is it extends to unit owners, their tenants, and their guests. So if somebody is just a guest that's just coming, like the UPS person, to drop off a package, if they're harmed, you know, we have a duty to take reasonable measures to protect against foreseeable activities that create a danger on the land it controls. So in our example with the Scottsdale Association, we had 2 notices. We had the small dog attack, and then we had the child attack. That should have been enough notice to this association that, hey, it's foreseeable that that dog is going to attack again. No question about it. It probably would have been foreseeable even after just the small dog attack. And therefore, if a pet is creating a danger, and it has to be a danger, it can't be a nuisance. For this liability to kick in, a nuisance is going to be barking, it's going to be dog poop on the common areas, but actual physical harm to someone.
What happens in cases like you look out to the common area and you see a dog off the lead and it looks like it's a Rottweiler? Well, I think it might bite. Well, that's implied. We don't know if it's going to happen.
But really, associations should already have in place restrictions that the dogs are on a leash or muzzled maybe even. That should be enforced on your common areas. That should be a rule. If you don't have that, that should be a rule right now for your association.
Something like my board always says, well, it needs to be the city's responsibility, the county. No, the association needs to take.
Well, the thing is, I mean, of course you can go to the city, but ultimately liability, like in the case of the Scottsdale Association, we're going to get sued, right? And so I guess, yes.
So, okay, there's the dog that's not on the leash. You know, I'm on a board and I don't like to be the policeman. I kind of let the association person kind of do the things and all, unless it's really bad, then I'll say, hey, come out and check this out. But here you are on a Saturday afternoon, there's a dog loose in the basically you're on the street, or I guess the only thing you do is go and approach the person, or
It probably won't be real well received, right?
or submit a violation report back to the association, so then it can be.
If you know who they are, that's the other problem. Sometimes it's a guest or it's a tenant or maybe it's an owner. I mean, I think what we need to do is have good education by posting of signs in the areas where the dogs are usually running. Typically it's green belts. And you know, you're not gonna be able to catch everyone, right? So have the signage posted, so that's one layer of protection. If there's ever an incident, and by incident I mean that you hear about an aggressive dog, you know, and you don't be surprised, you will hear about this. This isn't the type of thing that gets swept under the rug, like, oh, that dog, you know, growled at my dog and grabbed its tail or something, you know. That's something that we hear about because pets are a family member, right? It's just like having your child, have that happen to your child. So we always hear about the dangerous dog. It's then taking the next step and doing a little research and finding out who that dog owner was. Typically they do know who it is and they will tell us. And then we start documenting our file by writing letters and by reminding them, maybe we even levy a fine for the dog being off the leash. Maybe that, we have to look at each circumstance on a case-by-case basis. But what I'm telling you is to limit your liability, you have to come down hard on these situations. You must do something. You cannot just sit there and say, that won't happen again, because in my 22 years, almost 23 years of practicing in this area, there's a warning shot with all these dogs. Every dog's got one bite in them. Everybody always says that, but the warning thing is usually the precursor to the more serious injury. And so you have to act.
At what point do you call county animal?
Well, I probably, on the aggressive behavior of the pet, I would encourage the owner to contact animal control, because they have the direct knowledge. So if animal control comes to the association, we didn't see it. It's hard for us to comment on it, right? We weren't there, we don't know the date, the time. So document it in writing that we tell the owner, do a letter to them or an email saying, we encourage you to please contact the county to make this claim. Now, there may be some times where I actually have a board member that was bitten by a dog, and she had to have extensive hand surgery. There may be a time where the association has to make the claim because the victim is unwilling to do it, and then we just have to go with what we have. But typically what will happen is the county will come out, and if they can get in touch with the dog owner, they will quarantine the dog and require that a muzzle be used at all times. They're pretty strict on it. It's not forever. They will reevaluate the situation. But all of these steps are important to limit our liability. Because if we just sit there, let's say that we hear something bad happening, where a dog bites a child or another owner, and if only thing that we do is we listen, maybe we send a letter to the dog owner, it's not enough. We also need to get the county involved. If the owner's unwilling to do it that was bit, then we have to do it ourselves, because we're trying to spread the liability, okay? So once the county's involved, now they're also a defendant in the lawsuit, right? And it also is a preventative measure that we can't quarantine the dog, right? We don't have that in our documents. We can't require a muzzle, but if they don't do what they're supposed to be doing with the county, they lose the dog. So they know that. Everybody understands that it's very serious at that point. Yes?
We have one in our neighborhood who rides his bicycle with a gentleman, and he takes his dog with him. He lets the leash trail behind, and so if he gets stopped or anyone questions it,
He hasn't.
says, "Oh, I just dropped the leash and I'm trying to catch him." Well, I see him leave his house with the dog, with the leash, he never has the leash on the dog. So should we now go to the city?
I would. So just to reiterate the question so everybody can hear it, there's an owner that has a dog that he rides his bike, and then the dog is next to him with the leash on the dog's neck, and it's just trailing behind. That's really dangerous for dogs too. What if it got caught in the wheel? That is tragic. I'm not sure, is the city going to do anything on that? Is it a city-owned street?
It's county also.
County.
They're the ones who enforce the leash laws. So if they have them on a leash, you're supposed to report it on the leash. So I would definitely report, especially if you know where he lives. As you said, if there's something that happens and you can indicate the time of day that it happens, if you have that information, you'll be able to go out and witness it.
And I also think another point on that is if it's in the association that this is occurring, the association should be sending that owner a letter. And if anybody can get video of it, that would even be better, because you're right, that owner is going to say, "Oh, I just dropped it that one time." No, so when you complain about it, what you need to say is, "Hey, this is what's happening. Here's a short video of it, and this happens every day. This is only one video, but this happens every day." Yes?
I was mauled by two St. Bernards as a meter reader for the gas company, and in the lawsuit,
I'm sorry, that's horrible.
in the lawsuit, it came out that if somebody has a sign on their property that says "Beware of dog," they are acknowledging that their dog is dangerous. Can you comment on that? Beware of dogs.
You know what I love about this practice area is I always get new questions. I've never really heard that one. So if an owner places a sign on a location on their home that says beware of dog or dangerous dog, I think I've seen a bunch of different signs like that. Your comment was that it came out in a lawsuit that
Well,
it was
wasn't
like an
mine, but
admission.
I heard an example of a mail carrier getting bit.
Mhm.
And
I do think it's an admission that could be used against you. I mean, of course, you're using it to warn people and maybe even for safety for yourself, but I do think it could be used against you.
I think so.
Like why wouldn't that dog be tethered to something so that if you did enter the gate with a reasonable expectation that you're reading the meter or whatever, I think that could be used against them. Good point. Yes.
I have a question on the last sentence in that. It's on the screen. Therefore, if a specific pet is creating a danger within the association, well, what about a dog that is not creating this information? And then what do you tell somebody when they have a dog that is dangerous? And you say, well, so-and-so's dog is out running.
Without a leash. Without a leash. Same point. It has to be uniform for everybody. So whether it's cute little Fluffy or the big Great Dane, everybody has to be on a leash. And then you have to uniformly enforce it. And it's tough because you don't always know, are they an owner? Where do they live?
Well, that's true what you're saying, because we have 440 homes and we have extensive large green belts, big green belts, and it's hard to catch these people.
So I would say have signage. That's one layer of protection, reminding people that dogs must be leashed. And typically you'll hear about it after there's an incident. You can't hyper patrol. I mean, you can't have a dog patrol, right? So you're going to hear about it typically after there's an incident. You could use your annual meeting, you could use your newsletters, put it on your website, just reminders that for the health and safety of everybody, dogs need to be leashed at all times when on common areas.
3 years ago, we had a mauling of a very large dog, mauling another large dog and killing him. And the person had on a leash that did the mauling. And it was a child that was a special needs child walking this basset home. And we never could find out from the child what kind of pet it was. And he was so emotionally beat up by what happened. So, you got to try your best to make sure people keep dogs on a leash, and this was on a leash, unfortunately.
Yeah.
Control the dog. So.
I mean, these situations come up. What I'm saying, that's probably not preventable. Maybe it is, I don't know who had control of the dog, but what we're trying to focus on are the situations that are preventable. The ones where there's an incident, taking swift action, documenting our file, contacting the county, making sure, that there's follow-up to make sure that they are actually leashing the dogs. That's going to help limit our liability, but there's going to be things that happen. There might be a first time that the dog gets the first bite. And it's really ironic in the situation. I think I mentioned briefly that I had a board member that was bitten by a dog, and the dog really mauled the board member's hand area. And so we got involved. She had to stay out of all the discussions on it as the board. But we contacted the dog owner, and the dog owner tried to blame her. It was like crazy. They said that she came up with an aggressive stance to the dog, and the dog was protecting its territory. So there's a lot of, unusual responses that you get. And interestingly, the dog owner tried to actually sue the association, if you can believe that. And I believe that the association's insurance carrier settled with the board member, but it was like $80,000 in surgery, medical expenses. So, it's expensive, and she is a very gentle person. She was just going to lean down to pet the dog, and that's what she got. So, okay, let's do this. Let's take our short little break because I want everybody to get a little bit of the Mexican food that we have, and then we'll come back at about 2:05. I'll be in the front of the room if anybody has questions during the little break. Also, put your questions up on the parking lot wall if you have anything specific, and we'll finish up with those at the end. Thank you. Okay, the second half of our presentation, we're going to start off with just a case that I'd like you to be aware of. This case is a case out of Missouri, but remember that even though we're in, can I turn? Oh, you know what? It's not a microphone. They're videotaping so we can put this on the Chandler website. Sorry about that. I'll try to talk louder, okay? We're going to start out by talking about a case out of Missouri that is instructive to us on pets and associations because there aren't really that many cases that specifically deal with this issue. There are no Arizona cases, reported cases, that have gone through the appellate system. So sometimes we have to look at other jurisdictions. And so in this case, the Tatasek versus Homefield Gardens Condominium Association, in this particular association, the court held that the association had a duty to enforce the rules it promulgated regarding pets in the association. And this association had enacted rules, including a rule that the pets had to be on a leash, that the owners pick up pet waste, and that pets should not be unattended or create a nuisance, disturbance, or a noise. The bylaws also went on to say that no dog should be over 25 pounds. So we got a lot of rules here for pets in this association. A homeowner in the association was attacked by another homeowner's pit bull. She sued the association, arguing that the association was negligent because it failed to enforce the rules and to ensure compliance of the rules with pets. The Court of Appeals remanded the case back to the lower court for a jury to decide if the association exercised ordinary degree of care in their duty to enforce the rules. The court stated that whether a party exercised ordinary care is a question of fact. So what that means is that a jury will decide whether the board acted reasonably. And what the jury will look at is whether or not a reasonable person under the circumstances would have known that the pit bull was there in violation of the rules, and would they have taken additional measures or reasonable measures to protect the residents. So just a couple of points that we can make from this case. We don't have a case yet in Arizona on this. I don't want your association to be that case, right? And so a couple things. If you do have pet restrictions, be very mindful of any place that you can notify residents of the rules, use it as an opportunity to notify them of the rules. So put it on the website. Talk about it at the annual meeting and have it in your minutes. Talk about it at regular board meetings if it's becoming an issue in your association. Write letters to owners who are violating the rules so that we have a paper trail that we became aware that so-and-so had his dog off his leash, and this is what we did. Anything that we can do to show that we were trying to be reasonable and that we were trying to enforce the rule as best as we could will be used as evidence to help us. What you definitely do not want to do is hear about an incident and do nothing. Typically on these incidents, you need to act promptly. So within 48 hours of hearing about something, whether it's a bad dog bite or a dangerous animal or, something, it's one thing to have the guy with the leash that's trailing the bike. Nothing's happened yet, right? So of course that's important, but it's not a 5-alarm fire. What's a 5-alarm fire is the dog attacks somebody else and that person is injured. That is definitely something that you need to get your legal counsel involved, and you need to come up with a strategy as to how you're going to handle it. Typically, you need to contact your insurance agent immediately and place them on notice of a claim. You're going to need to address the issue with the dog owner. You're going to need to reach out to the owner that was injured or the resident that was injured. You're going to want to have a paper trail of different things that you're doing. You may want to contact animal control. But it's good to have somebody who's advising you when you get into a crisis situation on this so you don't miss anything. So I do like the idea of having you contact your legal counsel to discuss it, especially because you don't want to miss that chance to notify your carrier of the claim. We have seen some associations where they're aware of something that occurs on their common areas. I had a case many, many years ago where we had a playground accident where a child lost a toe on one of the, sorry, everybody's eating. Child lost a toe on one of the playground equipment at the association, and the association didn't do anything. They didn't notify the carrier because the toe was worth something, right? And that we were eventually sued for, the association was sued over that. Also, the equipment was never inspected, right? It could have happened again once we knew about it, so just whenever you have a crisis situation like that, make sure that you're conferring with somebody that's there to help you and can help you make good decisions. Okay, assistance animals. We talked a lot about, pets and dangerous activities by pets. Now let's switch gears and talk about the Fair Housing Act and how pets, assistance animals, are allowed under the Fair Housing Act. So if your association has a no pet policy, an occupant in the association may request a reasonable accommodation from the association's no pet policy. So what does that mean? So I think somebody before, is it okay if I use your example? Okay, good. So what we typically will see is like assistance animals such as a dog, like a little lap dog. And what will typically happen is that the association has a no pet rule. Or they have some other rule that pertains to pets, like it has to be a certain pound limitation, or it has to be a certain breed, or whatever. And an owner has a disability under the Fair Housing Act, and disability is very broadly defined, but typically it's a mental disability under the Fair Housing Act. And they get a letter from a medical doctor, has to be a medical doctor, stating that, Sarah needs her dog Flossie as an emotional support pet. And it's signed by, the doctor, the medical doctor. And the association gets this. They know that their CC&Rs say no pets. But now they have this letter from a medical doctor saying that a resident or an owner needs to have this dog. What does the association do? Under the law, we have to make what we call a reasonable accommodation. And what that means is that even though our documents say no dogs or no pets, we have to accommodate this person's request because of their disability. And so I get questions on emotional support pets and dogs all the time. Right before the class started today, this gentleman said that they have an owner at their association that needs emotional support chickens. And that it's been prescribed, maybe not by a medical doctor, but we think it might be a family friend. So when you get these requests, a couple things to think about. Number one, first of all, what do your documents say? Okay, this may not apply to everybody in this room because I'm guessing that most of you are planned communities and you're gonna allow dogs. But some of you may be in a condo where there's no animals allowed. First thing that you wanna do is look at the note from the owner and look at the medical doctor's note. Is it by an actual medical doctor? What does the note say? And then you need to make a determination. You may need to consult with your management company or maybe with your attorney to determine, hey, did they comply with the law? We'll be able to weigh in on that. A common question that I get is, that person doesn't look disabled. Why are we allowing this? It's tough. Sometimes I do think that some of these situations may not be legitimate, but it's what the law says. And if they have a medical doctor that says they are entitled to an emotional support pet, we have to allow it. So, and sometimes they'll give, notes from somebody that's not a medical doctor. You can go back and request that they get one from a medical doctor. That is something that we will typically do. What you don't want to do, because I don't want you to have to get involved in an open claim with the Attorney General's office, what you don't want to do is say anything like, we don't believe you, we don't think you're disabled, we think you're trying to scam the system. Do not say any of that. The only thing that we can ask for is verification that that person is disabled. And we can't ask follow-up questions. If a doctor says this person has a disability under the Fair Housing Act, we cannot say, tell us specifically what the disability is. That is not something that they're going to tell us. It's not something that we're able to do. And then just that they have to, what they have to have. Now, sometimes we'll see situations like the chicken one. That's a really good example. So no medical doctor signed it. So to me, on its face, that's invalid at this point. But maybe they do get a medical doctor to sign something that says that this person needs chickens for emotional support animal. I think that we are well within our right to limit the number of chickens, right? I don't think this person can have 40 chickens. Maybe it's 1 to 3. And I think that that would be a reasonable accommodation, but I don't think we have to allow the whole hen house, so to speak. Also, if any of these pets are creating a nuisance like the chickens are waking up and creating, a lot of noise or smell or unsanitary conditions, we still would be able to enforce our regular nuisance provision against them. They still have to be good neighbors. They still have to pick up after their pets. All of those things they still need to comply with. Let's see. Server function. Okay, so the three things, and I'll come right to your question then. So if your association receives a request for a reasonable accommodation for an assistance animal, in order to be protected by the Fair Housing Act, one, the person must have a disability that's defined by the Fair Housing Act. It's very broad. Two, the assistance animal must serve a function related to the person's disability. And most doctors just say it serves a function, and that's enough. They don't tell us what they're doing to serve that function. And then three, the request to have the assistance animal must be reasonable. Common requests include depression, anxiety, or emotional support. You had a question.
I do have a question. If the person was allowed to have chickens, or chickenette, does that chicken have to be with them if they go play dominoes, if they go to community meetings, if they go play poker or luncheons? Does the chicken have to be with them because they have a piece of paper that says they need that chicken with them?
On the common areas,
On the
yes.
common areas.
The assistance animal would be entitled to be with them at the pool, but the assistance dog or chicken or whatever wouldn't be able to go into the pool because that's a violation of the county regulations for pools. But within reason, yes, as long as it's not violating, like they may not allow a chicken into, if you're serving food or something at an event, Yes, you can specify that they still have to comply with other,
So what you're saying is
sanitary
they
type
can't
things.
Come see, come saw.
No, I think that it needs to be appropriate. A chicken is very unusual. Usually those chickens are going to be the type that are going to stay in the coop. But
the
the
dog.
assistance dog, I've seen those at the pool. I've seen them at community events. I've been at annual meetings where we have a whole parade of people bringing their dogs in.
But if they're out and about, they need to be with them because
Well, I don't think we can mandate that they have to be with them 24/7. That's not our job. We just have to allow them to have the assistance animal when they need it. Okay, a few more things. To comply with the Fair Housing Act, we can require them to provide proof of a claimed disability from a physician, require a physician's statement that the animal is necessary for the resident's disability, and three, require the resident to follow policies for the cleanup of animal waste, leash requirements. An assistance animal does not have to have specific training, like a sight dog or service animal under the ADA, Americans with Disabilities Act. Typically, associations are covered by the Fair Housing Act, not the ADA, because Americans with Disabilities require that the association be a place of public accommodation. So a lot of times boards get mixed up on that. The Fair Housing Act applies to associations. The Americans with Disability Act applies to public restaurants, public locations like this library. So the Fair Housing Act it's a different law. If you were trying to get a dog under the ADA, it does have to have specific training. But under the FHA, it's more lenient, and they do not have to have specific training for that pet to be an emotional support pet. Let's talk a little bit about dogs. Now, anything to close up on Fair Housing Act before we move on? One more thing I wanted to mention is right before the break, one of the gentlemen here in the second row came up to me and said, our association had a situation with a pet, I believe, that was off a leash. And we put the picture of the pet and the pet owner, I think it was it that, on Nextdoor. Oh, the motorcycle, that's right, but I was gonna make it to that. So they had somebody in their neighborhood that was using a motorbike and causing damage, potholes in the association's common areas. And they put a picture or a video of the person and said, does anybody know who this is on Nextdoor? We all know what Nextdoor is, right? And somebody knew right away who it was, and that helped us get to the perpetrator and get it resolved so it wasn't happening anymore. So, I'm very much in favor of Nextdoor. Just so you know, I think it's great. I think it's good for people to have a place to exchange information and to communicate about different things. I don't like to see some of the negativity that I see sometimes. If they disagree with how the board's doing something, they can get a little negative. But I think it's always good for the board to know what's out there It's almost better to have it in a public forum where you know what's going on versus behind your back, you know, and then you're broadsided at a meeting, at least. You know, at my association right now, we have a little scuttlebutt about something, and it's been all over Nextdoor. And I've educated myself about what the people are upset about, and I think I can better address their concerns at the next meeting because I understand what they're saying. It's not like I'm walking into the meeting and I fall into a trap door, right? I know what's up. I know what they're upset about. I've already reached out to the ringleader of it, and we're going to work it out. So, okay, let's talk a little bit about dogs and barking. Dog barking is a very common problem that we hear. Judy hears about this too. We all hear about dog barking. There are some ways to limit dog barking in the association. We actually have a whole cheat sheet on that on our webpage if that's something that you're interested in. You know, for several suggestions on that, take a look at our cheat sheet because there's a great mediation program, which I know many of you know about because we had the sample mediation here. But there's also some other suggestions on how to actually educate the dog owner on how they can limit the barking. If the association receives a complaint about a dog barking in the association should determine whether or not it has a nuisance provision in your documents. If it does, then we can send letters to the owner regarding the dog barking because that owner's creating a nuisance by their dog's behavior. The association can fine for that nuisance, and we could also, you know, if we wanted to, we could also pursue litigation. You know, go to the Department of Real Estate and file an administrative claim, or go to Superior Court and file a lawsuit. What I've found is that most dog issues can be resolved with good communication. What typically happens is the dog owner's not home, so they don't really understand how annoying it is that their dog's been barking for 12 hours straight. And so you need to document it. Whoever's complaining needs to give good documentation to us. You know, audio tape is excellent. Have a log showing how often the dog is barking. And then we go to the owner with the evidence. And usually, there's a little bit of a dance on it, but usually it can be resolved amicably. I don't think in my 22 years of practicing law, I have ever had a case where we've taken an owner to Superior Court over a dog barking case. We've always been able to resolve it. There's a Maricopa County ordinance that talks about dogs, you know, in terms of a bark, a yowl, a yip, or any other noise. After receiving a complaint about barking dog, the county enforcement agent shall investigate this. I will say, based on my experience, this is a little bit of a lower priority issue for them. They've got a lot of meaty issues that they're working on. And so, of course, you know, it's something that you can do, but it may not be the fastest way to get it rectified. Some cities and towns also have special mediation programs for dog barking, as does Chandler. The association can consider directing owners to the mediation program. And as you learned in our class, you need both owners or both residents to agree to have the mediation to resolve the issue before, you know, the mediation can move forward. Oftentimes, you know, we have seen a few cases where there's ordinances in cities, towns, and municipalities regarding dog barking. So in order for a criminal complaint to be filed against the dog owner for the barking, you first typically do have to go through the mediation program. And then if it's not resolved at the mediation and the problem's not rectified, then the city will consider doing criminal charges against an owner. And this is very serious. If the city pursues this, you know, it is extremely serious. Judy, how many cases do you think we see on this, though, really?
Oh my gosh, we get so many barks and dog calls, I don't know, but I mean, there has to be a lot of proof. There has to be continuous barking. You have to have like video to show how loud it is. There's just so many circumstances, but it is not a high priority call. And the police, they do go out, they do leave notices on the door of the person that has the barking dog to remind them what our policies are in terms of.
That usually does it, don't you think, when the police come? I think it usually does do that. So, you know, you can contact the city, the code enforcement, you can contact the police. The police won't come if it's Saturday night at 9 p.m. when it's the most, you know, serious time to be handling criminal issues, but just keep a log. If you're the complaining owner and the owner's coming to the association, tell them to keep a log, because that's the best way to document when it's occurring.
Simple fix, I mean, maybe the owner just turns on the television station and the dog barks at the TV while he's out working. And it could be something that's simple. It could be a dog that passes by the house that the dog sees that's constantly barking as it walks by the house. So there's a lot of circumstances, and usually mediation is a great avenue to get to the bottom of it.
I'm just thinking, I forget, I have all these cases in my head. We have a case right now where somebody they FaceTime their dog so that the dog now doesn't bark, so that they dial into, yeah, it is true. They just wanted to see something, and it did work, because they wanted to see the master or the owner, and they FaceTime in to the television. Okay, let's talk about chickens. Hot topic in Chandler, very hot topic in Glendale, where I'm going to be tonight for a meeting. Okay, well, first let's back up a little bit. The city of Chandler does have a prohibition on chickens. Is that correct, Judy? In residential areas. Your city has done an excellent job of fighting off any legislation that would allow chickens to be present in residential neighborhoods. And I've seen firsthand some great lobbying done, maybe 3 years ago, was that? 2 or 3 years ago? Where the city of Chandler took the lead on it, and they stopped a law, like literally dead in its tracks, so that's great. Okay, depending on where your association is located, you may have restrictions on chickens. Chandler, you do, no chickens in residential areas. There are some cities like Phoenix and Tempe that don't prohibit it. But here you do have a prohibition on chickens. So if your documents, so in your case with the chicken owner that it needs it as an emotional support pet, the city is also going to have to bend in Chandler on this and allow that chicken. But other owners, so let's give another example. Let's get away from the emotional support chicken. Let's just say I'm an owner that wants chickens. I look at the CC&Rs for Chandler Meadows, and chickens are allowed. Well, too bad, because the ordinance in Chandler does not allow chickens. And so that ordinance is going to be controlling here. Let's see. This is something that we do need to watch going forward. We have seen legislation being introduced almost every other year that would override the city of Chandler's ordinances and would allow chickens in residential neighborhoods. Also, some other county regulations also have this. It's just important for your association to know if most of you here today are located in Chandler, but some of you may be located in Apache Junction or somewhere else. Just know what your city's restrictions are on that, and then also check your documents to see if you can enforce it or not. One more thing on chickens. If your documents say commonly, accepted household pets, I don't think that a chicken is considered a household pet. So, I don't think that an owner can make that argument very well. Now we're going to talk about pot-bellied pigs. Almost the same analysis as chickens. Most associations have restrictions in their CC&Rs regarding common household pets. Some may have specific animals that are allowed, like cats and dogs. However, association governing documents may not address animals like a pot-bellied pig. We have an association in Scottsdale right now where we have an owner that has a pot-bellied pig, and that pig is on a leash, being walked in the common areas, and this particular association didn't have any pet restrictions. So it didn't say that you're limited to common household pets, and so they had to keep the pot-bellied pig. They are trying to pass a CC&R amendment right now to prohibit that. But the city of Scottsdale it's not part of their code, and they've chosen not to enforce the pot-bellied pig, any restrictions on that particular pig. You may want to define what household pets are, as you said, be a little more specific, and then if there's something that you missed, you can leave the open-ended thing that if there's an animal that's not listed here and you want permission, you can contact the board in writing, and we'll consider it in writing and respond to you. There have been some lawsuits around the country on the issue of whether pot-bellied pigs should be considered a household pet. An HOA in Texas, I know there was also one in Illinois, was attempting to enforce a rule that would require the family to remove a pot-bellied pig from the home. The HOA's rule permitted domestic animals commonly and traditionally kept as household pets. If you can believe this, the court in this case said that the pig breed was a household pet, and therefore the family was allowed to keep the pot-bellied pig in the association. Now, I try to pride myself on making good judgment calls for my clients. I have to say, I don't blame this attorney for bringing this case. This language is amazing. I mean, domestic animals commonly and traditionally kept as a household pet. That is not a pot-bellied pig, right? So I'm sure this is up on appeal right now. But I mean, I don't think you want to be this case, because these cases cost hundreds of thousands of dollars to litigate. So what you may want to do is the next time you do an update of your documents, start thinking about some of these other situations that you might encounter and do an amendment to address those. Javelinas. Actually, I had a war. I like animals, but I had a javelina war. And I don't know if anybody's ever heard me tell this story before. But we owned a home that was adjacent to the Phoenix Mountain Preserve. And at the time, we had little kids, like a 3-year-old and a 2-year-old. And we had a pack of javelinas that marked our yard. And they just created havoc for me. They dumped in my trash cans, they ate all my flowers. You know, they were aggressive because I'd be chasing them with a broom, you know, and they would come right at me, and I'd be running then. And so we do have, I think, javelinas and coyote, same analysis would be for both of these. So does your association have a duty to protect its residents and pets from wild animal attacks like javelinas or coyotes? What should your association do if javelinas or coyotes are spotted within the HOA? Well, first, you're going to hear about, it's more going to be coyotes, I think. But the javelinas, if they're angered, they can become a little more, they can attack you more, and they're much larger than a coyote. I think if the association hears about coyotes in your neighborhood, it's a wild animal. You cannot control a wild animal, right? And they're entering the association at different border points. You're not going to be able to control that. So I think the key thing is education and communication with your owners. You will want to contact them and say that, listen, we've been notified by several residents that there's been coyotes that have tried to attack their small animals, or that they've been aggressive in their stance when people are out walking. We're making you aware of this so you can be aware of your surroundings. Basically that's all you can do. I mean, if let's say a wild animal does attack a resident, you want to have that documentation in your file that we were notifying the owners if we had knowledge. And that's where like a Nextdoor really can come into play well, or a Facebook page for your association, or a website, or newsletters, or talk about it at your annual meeting. Typically it's just certain times of the year, and it goes in phases. But as soon as you hear about this from somebody, I think you do have an obligation to notify your residents. You might want to adopt some regulations to make it less likely that the javelinas will want to be in your neighborhood, like trash cans. I mean, that's typically why they're there, because there's a good food source. Javelinas need water and food, and the garbage is typically the food, and then they want a water source. So if somebody has an area, we had a fountain, and the javelina loved that. So what we did to get rid of them, I did try to hire all animal transport to trap them, because it really was a situation at our home. They never could catch them. We'd even put out like leftover steak or something, which they said for sure would catch them, didn't catch them. What we did to get rid of them was we put up a temporary orange fence around all the food sources, and within 2 weeks, gone. Never came back, even though they had marked our yard. So that was how we got rid of them. I wish I'd done that first. That would have been a lot less expensive.
Beth, did you think about calling Arizona Game and Fish?
I did. We had to get a license before we could have all animal transport come out to, transport them out into the wilderness. So I paid for a license. Should have just done the orange fence. But it took a couple rounds with the orange fence because they were like, this is like my war against the javelinas. Finally, we had to like put all of our patio furniture up against the orange fence, and then we got them. So again, we're not going to be able to predict when wild animals will enter the community. However, if we become aware of it, we really do need to notify the owners. Javelinas are classified as big game animals in Arizona and protected by Arizona state law. So if a javelina is damaging your property, you do have a legal right to use reasonable measures to protect your property, but it doesn't include capturing, injuring, or the unlawful killing of an animal. And every once in a while, I get a board that we've got somebody who's, has a gun or something, and like, I can just take care of that. Be very mindful of that. You do not want anybody on your board to ever do anything like that. That would clearly be a breach of fiduciary responsibility. Yes?
That same law, if I understand it right, also applies to feral cats. So, because they are classified as a wild animal, because they're free roaming, they're allowed to free roam. So, part of when they were talking about the trap neutering release program is you cannot release them out from where they were taken from. They're taken out in the desert and let go. That is a violation of state law because they're protected. So you have to be very careful. Yeah, they have to be returned back in.
I'd be curious where all animal transport takes them. I think they take them to the Humane Society, which I think means that they don't get returned. I think they take them to the Humane Society. No, the javelina, there's a special permit and there's a special area. It's very expensive to deal with the javelina. It's like $1,000.
But the understanding is the trap neutering return, it has to be followed by the rule of return. So if they're taking them somewhere else, then they're
violating the law.
Setting it up because they
That's
can't
good to know.
where they got trapped.
You can bring them to the Maricopa County Animal Control, they'll charge you $95 for a feral cat.
Yeah.
If you trap a regular cat, a household cat, they won't charge you.
Right, that is correct.
Yeah.
That is correct.
So it's expensive. So if you have 50 cats, 20 cats, you've got the transport fee and then $95. That's a lot of money.
Actually, with the trap neutering, there are some companies actually in Arizona that will do that. Actually, they are called that program, and it's not that charge. It's I think it's like $25 or $40 per
Okay,
cat.
good.
And they do that as part of the program, and they carry the licenses to do that, so you can only allow to trap so many, and then those are taken to the veterinarians that are set up to work with them, but they have to come back to your neighborhood.
Wow. Okay, that's good to know, because if any of us are hiring a company, we want to make sure that they're complying with the law.
This sheet of paper cites the ARS 132910, which has all of the statutes related to pets.
Oh, good.
Cats.
I'm going to grab one of those. That'll be good to have in my library. Yes.
There's also a program through the Humane Society where they will take cats and work.
Could you ever go get that posted on the wall for me? The post-it on the wall. The one that has writing on it. Could you ever bring it to me?
And so the cats basically earn their keep by keeping the rodents under control in their houses, especially food warehouses.
Really? So they would remove them from one area and then put them into that? Wow. Well, I think that's great. I really do. I think that's great. Thank you. Okay, we're going to finish up. So this is kind of the end. A couple things just to remind you before we do the parking lot. Remember, we have our memo that we put out for our firm. Some of you may already be on it, but if anybody wants to be added to our mailing list, once a month we do a memo on new case law, new legislation, just helpful information for boards and homeowners. So if you want to be added, use the red clipboard. Then don't forget, we have our first Friday free call-ins. I think at least half of you have already participated in this. I know that. It's the first Friday of each month. It's free. All you have to do is call between 9 and 10 a.m. The next one will be in November, the first Friday. And then we're on Facebook, Twitter, and our website has a lot of information that's free for board members and homeowners. And then 2 questions. Chandler, how many dogs can live on or at a property? Do we know that?
I don't think we have a restriction. I think what it is as long as they're maintained we don't really have a number. But if you're not big enough after your dog, and you got 10 dogs, we're gonna.
And the county's going to come talk to you too, because if they think the animals are being abused, if you have a large number of animals, you'll see those cases from time to time on the news channels. And they do get involved, but it has to be extreme. It's not like 5 pets, it's going to be like 10, 15.
We have hoarders, people that hoard cats in their homes, so, and eventually that smell, that odor, it does get through.
Oh, it does. Let me tell you, I had a case once where we had a lady that had it was a 1-bedroom apartment or 1-bedroom condo, and she had at least 30 cats up there. And I had to go in and do the inspection as part of a lawsuit. We were suing her. And I'm pretty tough. Like, I grew up in Wisconsin. I'm used to manure. Like, I've cleaned chicken coop. I actually left that thing. I went right home and I threw out everything I was wearing. Literally. It didn't even, at the back door. Like, it didn't even come in our house. My shoes were soaked it was so bad. And I can't even imagine the lady that lived underneath. She was still living there, and there was stuff dripping down the walls. It was so horrible. Felt horrible for her, but we got her out. Yes?
Let me give you a fun story.
Okay.
Behind your house is a portion of the houses on the other side. I call her Buddy, but she's mine. Not a real problem, but once in a while you hear her. If I go out to my backyard and she hears me, she talks to me.
And this is a cat?
The dog.
Oh, dog.
So I have to answer her. But like, I don't want to get a kid in trouble in the restaurant for talking to me.
Right.
Then I have to tell her, okay, that's enough. Now you go lay down. And then I have to be real quiet about what I'm doing because I don't want to get the dog.
Oh, that's sweet. That's a good neighbor.
But that's Mom.
That's a good neighbor. I like that story.
Go for a pet. That was a great pet.
Yes. Okay, last question. Can a board seek full money owed if a homeowner breaches an agreed upon settlement between an HOA attorney and a homeowner attorney? Well, yes, but here's what I would say. This is going to be for an owner not paying assessments or fines. How you need to set it up is when you do a settlement with an owner. So let's say, for example, the owner owes $5,000. And you say, if you give us, we'll accept $4,000 on the $5,000, right? But you got to pay, $2,000, October 1st, and you got to pay another $2,000 January 1st, right? You got to write it up in such a way that if they breach any of the payments, they're still responsible for the full $5,000. If it's not written up that way, it might be hard to go back and say that they still owe the $5,000. And we're seeing more and more. I just actually had a meeting with my office this morning on this, saying, we're always happy to do a payment plan with an owner. We always are. But it's one time. If you breach it, that's it. And we have to tell them that up front, that's it. Here's the payment plan, you're signing this. And if you're doing a payment plan as part of a lawsuit, what you should do is make sure that you get a stipulation to judgment. So if they breach the payment plan, bam, we got a judgment. We can go garnish their bank account, their wages, their rent, sell things to get our money back. And so you want to be smart on how you're structuring the settlement. So A, our goal is to get the money in, but B, if they don't live up to it, we're aggressive and quick to take the next step, and we should be getting the full amount. This is a one-time deal. That's a pretty good discount. $4,000, $5,000's old, get $1,000 off. That's a really good discount. So, just tell them as part of the settlement, if you breach it, you pay it.
Why are you seeing more and more?
Well, I think the economy's better. I genuinely do think, we're not having to file as many lawsuits. There was that article in the paper recently about the increase in the number of foreclosures. I don't know if any of you saw that in the paper for HOAs. I think that that's a result of the fact that people have equity in their homes now, and that foreclosure is a viable option to get people to pay. And people have money, and they have equity in their properties right now. So people should be paying. You shouldn't be having a lot of delinquencies right now. So, okay, thanks everybody. Is this the last class for the whole series? Okay,
Thank you.
good. Thanks for having me.